Welcome to LexiCast, a podcast designed to help you grow in your legal practice, with weekly updates on current topics, trends, and practical insights. Perfect for listening on the go. Let's dive in.
Welcome to the Deep Dive. For about 2 decades now, something significant has been shifting in the legal world. It's moving beyond, the traditional courtroom.
That's right.
Courts are facing immense pressure, we all see it, and clients and professionals, they're actively looking for smarter ways, for alternatives.
They really are.
So today, we're doing a deep dive into one really powerful alternative that's genuinely changing how disputes get resolved. Let's unpack this. What's really driving this shift away from the old ways?
Well, what's fascinating here, I think, is that traditional litigation, it so often forces this kind of zero-sum game, doesn't it? It can just destroy goodwill, pull relationships apart.
Absolutely. We see it all the time.
But what's emerging now is collaborative practice. And it's a process that completely flips that script. It's quite a remarkable solution, not just for settling disputes out of court, but, and this is key, for preserving human relationships.
Preserving relationships.
Exactly. It actively designs for, mutual gain, even in really tough situations like contentious divorces or, say, business splits. It fosters an environment that's open, transparent, and, importantly, respectful.
That idea, mutual gain, it sounds almost revolutionary, maybe, especially in a legal context. So maybe for you listening, what is collaborative practice really at its core? How is it so different in achieving that client-centered outcome?
Okay, so at its essence, collaborative practice is a legal process, yes, but one that brings together lawyers and allied professionals, think coaches, financial experts, and the goal, to craft genuinely bespoke solutions.
Bespoke.
And its client-centered nature is absolutely fundamental. It puts the client's wants, needs, values, goals, their wishes right at the absolute heart of everything.
Right.
And look, this isn't just some nice theory. It's driven by very real needs, both from clients and, frankly, from practitioners, too. Clients today, they're more informed. They're often weary of the huge emotional and financial cost of litigation. They want holistic solutions. They're asking, where do we want the kids to go to school, not just who gets the house. And for lawyers, it tackles that urgent need for better work-life balance. Moving away from those exhausting litigation models helps avoid burnout, gives us more control over the pace of a matter.
That dual focus on the client's whole life and the lawyer's well-being, that's powerful. So what are the specific advantages then for us as legal professionals considering this approach? And what are the core features that make it actually work?
Well, the advantages really flow from its unique structure. First off, there's something called a participation agreement. Everyone signs it, clients, lawyers, other professionals involved.
Okay, what does that do?
It's not just paperwork. It's a solid commitment not to litigate. That's the big one. And that promotes open, really transparent discussions, all on a without prejudice basis.
So what's said in the room stays in the room, legally speaking.
Pretty much. It means anything discussed can't be used against you later in court if, for some reason, the collaborative process breaks down. That gives vital security, for everyone, lawyers included.
Makes sense.
What else? Second, the measure of success. This is different. It isn't just about getting a winning legal outcome. It's about meeting the client's own articulated goals and interests.
So it requires a different skill from the lawyer.
It does. It really pushes us to build skills in helping clients dig deep and articulate what truly matters to them beyond just the legal points. Then third, you have the multidisciplinary team.
Right. You mentioned allied professionals.
Exactly. Lawyers, coaches, sometimes called communication facilitators, financial professionals, maybe child specialists in family cases. Each person leverages their specific strengths. It's efficient, and it gives really comprehensive client support.
Okay, the structure sounds robust, but what about the actual problem-solving part? How does collaborative practice guide people to these bespoke solutions you mentioned?
That's where the four-step problem-solving framework comes in. It's fundamentally based on interest-based negotiation. But it's not just splitting the difference,
It's just compromise.
No. It's about unlocking potentially new solutions by digging for the real drivers behind what each person is saying their position is. It starts with identifying underlying interests. So if a client says, I just want to keep the house, the collaborative lawyer asks us why.
Okay.
Is it sentimental value? Is it about the children's stability? Maybe a feeling of security? Uncovering that why, it changes the whole conversation.
I can see that. Then what?
Then we move to brainstorming options. Lots of them, without judging initially. Then evaluating those options specifically against the client's goals we identified earlier. And finally, settling on a solution that best meets those underlying needs.
It sounds incredibly thorough, like a well-oiled machine almost. But let's be real, what is collaborative practice not? It sounds like it demands quite a lot from everyone.
It absolutely does. And it's important to be clear. It's not always easy. It's definitely not always peaceful. It can be emotionally intense work.
Right.
And while it's generally less expensive than drawn-out litigation, it's not cheap. You're involving multiple skilled professionals. And crucially, it's not some kind of miracle cure for every single case.
Okay, so that raises a key question. Who is it right for? And who isn't it for?
Good question. It tends to work best with clients who are genuinely focused on preserving some kind of future relationship, maybe co-parenting or ongoing business dealings. They need to be open to transparency, willing to share information, and have a reasonable degree of emotional intelligence to handle the process.
And when is it not suitable?
Well, it's definitely not encouraged and often outright inappropriate where there's serious issues of power imbalance, domestic violence, or dealing with very high conflict, combative individuals. The whole process really relies on everyone feeling safe and being able to participate productively around the table.
Understood. So this deep dive really highlights collaborative practice as a powerful, very client-centered alternative, but one that definitely demands a new kind of legal skill set, perhaps. So for you listening, what does this all mean? Well, if you're seeking respectful, truly out-of-court resolutions for your clients, it offers a really compelling path forward for your practice.
And maybe here's a final thought to take away. While collaborative practice isn't the answer for every single client or every situation, the skills you develop through it, that client-centered questioning, the interest-based negotiation, the teamwork aspect is incredibly valuable. They can genuinely enrich any legal interaction you have, whether you end up doing a full collaborative case or not. It's really a skill set for the modern lawyer, applicable across the board in dispute resolution.
A powerful thought indeed. Thank you for joining us on the deep dive.
That's it for today's episode on LexiCast. If you're looking for more in-depth episodes that can also be claimed as CPD activities, check out our LexiCast CPD Plus page linked in this episode's notes. Follow us now to stay up to date, and we'll see you next time.